Hello, I'm Stephen Bernstein, Global Chair of McDermott Health. I'd like to welcome our regular listeners to our Governing Health podcast series, in addition to those of you listening to us for the first time. Each month, our partner, Michael Peregrine, welcomes a new guest into the studio to discuss some of the most pressing matters facing boards of directors, with particular focus on health and life sciences organizations. On behalf of the Health Practice Group at McDermott, it's a pleasure to have you join us.
Hello again and welcome. I'm your host, Michael Peregrine. We're pleased to have you with us. Today's conversation focuses on a matter of basic concern to the healthcare director, the extent of D&O coverage available to the board. So much of today's governance discourse deals with the tough stuff, the complexity of the issues on the board agenda, expectations of director engagement, and the financial, regulatory, and competitive pressures affecting the healthcare company. It's an increasingly difficult and demanding job, and there are more than a few people with direct interest in whether board members are doing their job properly. So it's completely natural to be concerned about individual liability exposure and the scope of available insurance coverage. That's even where the judicial burden for sustaining a breach of fiduciary duty allegation is awfully high. The need to demonstrate reckless behavior. But as my partner Bill Smith is fond of saying, you may be able to avoid the result, but you won't be able to avoid the ride. It's just very simple. Effective and committed boards deserve adequate D&O coverage, and they also deserve to understand the holes and exceptions to that coverage. And to help us consider these issues today, we welcome Kevin LaCroix. Kevin's an attorney and Executive Vice President of RT Specialty, an insurance intermediary focusing exclusively on professional liability insurance issues. Kevin's also the author of the widely followed blog, the D&O Diary. I read the diary every morning and find it to be the most credible resource out there on the subject. So when clients asked for a podcast dedicated to D&O issues, there was only one person I thought of as a guest. In our regular Looking Back episode, let's return to the subject of business disruption, something we think should be at the top of the healthcare board's agenda. Since our conversation with Ken Kaufman earlier this summer, there's been a lot of talk about digital technology in healthcare and the potential for digital-based disruption. It's an area in which healthcare companies have a lot at stake with their emerging investments in EHR, back office efficiency technology, telemedicine, and other consumer engagement mechanisms. Yet with all of the digital advancements being implemented by health systems, there remains a significant potential for disruptive technology to develop. Now, AI is the most obvious example, but there's lots more. Like the strategic relationships that are being created to implement precision medicine and the expanding notion of healthcare created by the digital environment. The board's going to be expected to assume a leadership role in both addressing the opportunities that digital technology offers and in defending its existing market position from new and disruptive digital technologies. To get this going, it may need a dedicated committee position in both executives and board members who have digital competence and diversity of digital experience. And now joining us by phone is Kevin LaCroix of the D&O Diary. Kevin, welcome to the program.
Thanks, Michael. My pleasure to be here.
Well, we're delighted to have you, and it really is a subject of tremendous interest. I noticed your subject in the diary today was on insurance in the healthcare area. And let me begin by kind of starting basic, because I think it's probably the fundamental question. When you interact with company officials about their D&O insurance, what's the number one question you get asked?
I speak to corporate executives frequently, and it is really striking how often I get pretty much the same question is, how do I know that I'm covered? And I can certainly understand from their perspective, they want to know that if there's a claim, there's a lawsuit with their name on it, that they can count on having their insurance coverage there to protect them. I usually start my answer to that question at a slightly prior analytic point before we even talk about the insurance, which is to talk with them about their indemnification rights from their employer or their organization, because the indemnification is their first line of defense. They want to make sure that their organization's corporate bylaws provide for indemnification, and hopefully they can confirm that indemnification and advancement are both mandatory and not permissive. Then, having determined that they have appropriate indemnification rights in place, turning to their insurance, they want to confirm with their general counsel, first and foremost, that the company has D&O insurance in place, and if it has D&O insurance in place, how much the company has in place, and how the insurance is structured. Those are the most basic questions. Obviously, there's a lot of other things they might want to know, but they want to make sure that they have insurance in place, because if there is insurance in place, odds are that if there is a claim in which they're named as an individual, there will be insurance protection there to protect them. Obviously, many other issues they want to discuss with their general counsel about indemnification advancement and insurance, but just making sure that there is indemnification in place in the corporate bylaws and that the company carries D&O insurance are going to be the first way to reassure that executive that if they do have a claim, that there are going to be protections available for them.
In healthcare, Kevin, we're seeing an extraordinary explosion of the size of healthcare organizations and the complexity of their business and the scope of their portfolio. So they're getting bigger and more complex. How can company executives and board leaders determine when they've got enough insurance, especially if you assume these organizations are growing almost exponentially?
Well, the answer to the question, how much insurance is enough insurance, is a multi-level answer because it involves issues such as affordability and risk tolerance. Some organizations are more risk averse and will buy more insurance. Other organizations are more cost conscious and will buy less insurance. But given the growth that you've just described, I think every organization should review the amount of insurance they buy every year. And they should insist that their insurance advisor provide them benchmarking information that goes to answering two kinds of questions. One is peer purchasing patterns. How much do similar kinds of organizations buy? But the other is, what's the scope of liability, and what would the demands on the insurance be in the event of a serious claim? And for a healthcare organization, serious claim might involve multiple different kinds of proceedings going on simultaneously, and the defense fees alone incurred in defending that type of claim could quickly erode limits of liability. Those kind of things definitely need to be taken into account. Again, there's no single answer that's going to be the right answer to the question, how much insurance is enough, and different organizations are going to answer it differently. But the company should review that regularly, particularly if, as you said, they're experiencing that kind of growth, because definitely the answer to that question is going to change with that kind of growth.
Kevin, is it typical that the board interacts with their insurance advisor through the general counsel or senior executives, or do the advisors interact both with the corporate executives and board leadership at the same time? What's your experience?
Different organizations take different approaches. I certainly have companies that I represent where they require me to meet with the board of directors at least once every year. And then there are other organizations where I've never met the board, and my interaction with the company is strictly limited to either someone in the GC's office or someone in the finance office. And it's really just a question of how the senior officials feel that their board wants to be informed about their insurance program. I will say, my experience is, even if they tell me I only have 5 minutes on the agenda for the board, frequently an hour later I'm still talking, because it turns out the board members have a lot more questions than they even realized at first. So it is something that I think is probably healthy from time to time, to give the board an opportunity to speak directly to their insurance advisor, because I think they'll find they do have a lot of questions. But clearly there's nothing wrong with organizations that choose to save their time at the board meetings for other topics. It's really just a question of how the board and the senior corporate executives want to use their time with the board and how they want to transmit information to the board about their insurance program.
Let's kind of pivot for a second to another question that's in healthcare. Since it's so highly regulated, it's always a concern, and that's the potential that the organization may lose its insurance coverage if it turns out that they've got any number of situations in hand. For example, if a corporate official is indicted or otherwise accused of fraud or other misconduct, what is the risk of losing insurance on a D&O level as a result of either allegations or determination of malfeasance by an executive?
Well, anybody involved in the kind of claims that come up against corporate officials knows that the allegations are serious and often include allegations of misconduct, including perhaps even fraudulent misconduct or criminal misconduct. The most important thing to know is that mere allegations alone are not going to trigger any exclusionary provision. And it's also probably important to note in this context that the policies are set up to provide coverage, at least defense cost coverage, for criminal allegations after indictment. So if an individual should find themselves as a criminal defendant in a prosecution alleging misconduct, they would be able to look to the insurance policy, at least for their defense costs. What would trigger the exclusion and preclude coverage is if there's an adjudication that the precluded conduct has taken place. If there is a judicial determination that fraudulent misconduct has taken place, that could result in a preclusion of coverage. The important thing for company officials to know that even if another executive is found to have violated the standard and triggered that exclusion, most policies these days are set up so that there's so-called severability of exclusions, so that the determination that one individual has been adjudicated to have violated the standard would not preclude coverage for others. So, this is an understandable concern that companies could be accused of serious misconduct, but again, mere allegations alone are not sufficient to preclude coverage. And even if there is an adjudication that one or more individuals have violated the standard, that would not preclude coverage for the other officials. So the chance that a so-called innocent director or officer would find themselves without coverage is a remote possibility under the heading of could misconduct by another official deprive me of my insurance coverage. It's set up so that only the individual that's engaged in the misconduct and adjudicated to have engaged in the misconduct will lose their coverage.
Let's stay on that subject. Sometimes corporate officials and compliance officials need the hammer of exclusion to drive correct organizational behavior and individual behavior. Are there exclusions for conduct such as conflict of interest or other violations of the duty of loyalty? Again, focusing on an individual. Can you speak to other aspects of exclusion that, in other words, conduct that if board members were aware that this type of activity would cause them to lose their coverage, they'd change their activity?
It's interesting the way you put that the presence of the exclusions are there to help motivate behavior. I can certainly see how that's
absolutely,
the case.
Absolutely, I'll tell you.
Yeah, and to that extent, then the exclusions do serve an important function. But the core of your question, how would the policy respond in the event of an allegation of breach of fiduciary duty, conflict of interest, and so on? I mean, from my perspective, as someone that's been involved in D&O claims for over 35 years, that's the essence of what this coverage is there for. Those are typical allegations, and you frequently find those kinds of allegations in claims brought against the directors and officers. And the policy should respond, particularly for a breach of fiduciary duty type claim, because that's the essence of an allegation that the director or officer have violated their duties in the course of their conduct as a director and officer. Sometimes there are allegations of conflict of interest. Again, mere allegation alone is not going to preclude coverage, and whether ultimately coverage could be precluded depends on whether or not there's an adjudication that an individual has engaged in conduct that would trigger the exclusion, usually phrased in terms of fraudulent or criminal misconduct. So in the absence of an adjudication, again, the mere allegations alone would not be sufficient to preclude coverage. And even if there is an adjudication, it would only preclude coverage for the individual found to have violated it. The important thing to know, though, is, those are the kind of claims the policies are there to protect against, and the defense costs incurred in those type of claims, and typically the settlement as well, all else equal, should be covered by the policy.
Is there something of a third rail that if you were advising a board saying, this isn't the area of conduct where if you engage in that, I can pretty much guarantee you're not going to be able to assert coverage?
You can certainly come up with absurd hypotheticals. I don't think any company would ever do something like this. But if they were to get express legal advice that a proposed plan of conduct violates some criminal statute, and they nonetheless went ahead and did it, I mean, that sounds like a formula for a lot of problems, among which would be potential loss of your D&O insurance coverage. I don't think very many companies proceed on that basis, and I think a lot of times they only find out in retrospect that conduct may have violated a criminal standard. One thing that is going to cause a problem for any organization is if they become aware of potential problems somewhere in their operations and they sweep it under the rug or disregard it. And that does happen, and I've certainly seen that. And that can clearly cause issues. I mean, we all remember from the Watergate era, it's the cover-up that caused the problem. If a company finds that there's something unfortunate has happened in their operations, and they make a clean sweep of it, and they aggressively move to correct it and to root out the problem, those kinds of companies are going to have less of a problem. But if they take a contrary course and try and keep it quiet and sweep it under the rug, that's where companies get in trouble, is when they don't confront their problems and they try and sweep things under the rug. That could result in many problems, including, for instance, even the potential loss of the insurance coverage.
Let's pivot for a moment to our regular short segment, What's Trending Now, when we try to flag a new governance issue we see on the horizon. And for me today, that's the renewed focus on overboarding, the concern with director distraction caused by service on too many corporate boards. Governance regulators and other interested parties are increasingly zeroing in on the issue of director engagement in multiple perspectives. Just how much time, effort, energy, and concentration is the director contributing to his or her board service? Is the level of engagement at the healthcare company board suffering because of responsibilities to other boards? That's the question that originally rose in the Sarbanes-Oxley era, and it's fittingly reemerging now with the 15th anniversary of that act. It's something that governance and nominating committees need to keep in mind when evaluating director performance. Should there be a limit on outside board service? Is it fair and reasonable to ask directors to reduce their other board activity as a prerequisite for continued service on your board? When you consider that it's all about director engagement and getting the most attention from an individual director, these may be fair questions to pose, at least at the governance committee level. And now let's return to our conversation with Kevin LaCroix of the D&O Diary and our discussion about trends in healthcare D&O insurance. Let's talk a little bit about something that's in the papers just about every day, and that's cybersecurity issues. And to a certain extent, we can say cybersecurity has just been beaten to death, but every day you pick up the paper and you say, no, it's not. How are you advising boards with respect to the possibility of a D&O claim in the wake of a data breach incident? Because we get that's a crucial issue for healthcare organizations and their privacy concerns.
It It's a question I get a lot, and it's actually interesting to me how quickly things have changed. I mentioned earlier I've been involved in D&O insurance issues for over 35 years and talked to boards for years over that time. And almost always what I was talking about was corporate governance and executive liability issues. But in the last 2 or 3 years, it's really changed. And what I find myself talking to boards about pretty consistently these days are cyber liability issues, not just the technical issue of whether or not there are vulnerabilities that can result in the breach of sensitive information, but rather the possibility that the board and corporate executives will be held accountable for the supposed failure to protect against that type of breach. And there certainly have been claims in which shareholders and others have alleged that corporate officials have violated their duties by failing to prevent breaches or failing to disclose that breaches have happened. By and large, those cases haven't been successful, but they have continued to be filed. And here in 2017, a couple of high-profile examples where there have been, in this instance, securities class action lawsuits filed in the wake of announcement of data breaches. We have Yahoo, which experienced significant breaches, in fact, the largest data breach of all times. And then more recently, Equifax. Both of those companies have been sued by investors who claim that they were misled about the level of security that the companies deployed. Whether or not those claims are meritorious, they're still serious, and they present a challenge for the companies and the individuals involved in those cases. In thinking about these kind of issues, one question that especially healthcare officials are going to want to ask is there anything in the D&O policy that, were there to be that type of claim, might create coverage issues? And the reason I think this is of particular interest for companies and healthcare organizations is, by and large, carriers are not putting exclusionary provisions on for these type of claims. By and large, they're really not changing their terms and conditions in light of the potential exposure. However, in the healthcare space, we are seeing some carriers that are trying to put exclusions for data breach-related claims on their D&O policies. And so that's clearly something that would be of concern for any healthcare organization if their policy had that type of exclusion. Definitely something that they want to explore with their general counsel and also with their insurance advisor, because it is something we are starting to see, and it could wind up being of concern for a healthcare organization if they were to have one of these kind of claims and their policy had that type of exclusionary provision.
I think concern is a bit of an understatement in that area.
Yeah.
Let's kind of move to a different aspect of the D&O coverage issue. We hear sometimes from board members and retiring officials that they're concerned that they're going to lose their coverage when they retire or resign their board position, even though they may be subject to exposure for actions that occurred during their time of service. Is this an issue that officers and directors should be worried about, the question of tail?
Whether they should be worried or not, I know it's something they are worried about. I get that question myself as well. And I can certainly see their point if their assumption is they're only covered as long as they remain in their position. The good news from their perspective is that all D&O insurance policies define the definition of insured person as past, present, and future directors and officers. So even if they've resigned their position and they've moved happily into retirement, they can feel comfortable that if there is a claim against them as individuals for their conduct during the time they were in their position, that the D&O insurance policy will protect them as well as those who remain with the company. The concern there is that answer is true only as long as the company continues to renew its insurance. And you can certainly imagine circumstances where a company might not renew its insurance, for example, if it were to become insolvent. There are solutions available in the marketplace to provide sort of that extra measure of protection for retired officials. There is a policy called a retired director's policy that provides coverage on an excess basis for any D&O insurance that is in place, but it remains in place for 6 years. It's non-cancelable. So it would provide the retired director an extra measure of protection against the possibility that the company might, in some future year, fail to renew its coverage. But typically, for most individuals, they're going to continue to be protected by the company's or the organization's D&O insurance plan, and that will continue to protect them even after they've left their service to the organization.
And they'll find that very reassuring. Kevin, before we wrap up, look into your crystal ball. What are the one or two big picture themes or concerns or developments that you see on the horizon as it relates to coverage?
Well, we've certainly talked, my number one topic, which is coverage for D&O claims arising out of data breaches. So that's my number one. Number two, there are emerging claims that at this point there aren't that many of them, but we've seen them where there are claims relating to climate change-related issues. Probably not as big a concern for those in the healthcare field, but certainly they could continue to see claims related to environmental issues. I think anything having to do with patient privacy, whether or not we're talking about cyber-type breach, I think those are going to continue to be important issues. And again, for organizations in the healthcare arena, regulatory issues are always going to be a continuing problem, particularly antitrust and other type of anti-cartel type enforcement. There are probably a limitless list of other issues. One of the reasons I like what I do is that I've been doing this 35 years, and it's always something new. So I think if we were to have this call again in 5 years, we'd find that we're probably talking about a whole new list of topics beyond what we talked about today.
Well, I think then the recommendation I'd have for the general counsel that are listening on the program is to do what I do in this. After reading the sports section, to turn to the D&O Diary, because, Kevin, you keep me up to date on, first things first, you keep me up to date on what's important, what's new going on in the D&O area. And I think the most fundamental takeaways today for our listeners are, number one, to continue to engage with the general counsel on the level of coverage, and number two, to monitor the cybersecurity area and the potential for exclusions in future coverage, because I can see the concern that arises from there. Kevin,
absolutely.
Thanks so much. I think all of our listeners really learned quite a bit, and were reassured by some of your comments. So thanks for joining us today, and enjoy Pentwater.
Thank you for having me, Michael. My pleasure.
All righty. Thanks so much. As Kevin has just told us, the matter of D&O coverage is as complex as it is necessary. Concerns about the scope of coverage, as well as exceptions to coverage, are natural and legitimate. Board members are encouraged to periodically discuss D&O coverage issues from their general counsel or other insurance advisor, and to get periodic updates on developments with respect to coverage. Greater comfort with coverage should free directors to be unrestrained in the prudent exercise of their fiduciary obligations. Thanks so much for joining us for today's episode of Governing Health. Be sure to subscribe to the full complimentary podcast series. You can find us on iTunes, SoundCloud, and YouTube. There you'll be able to stay up to date with all our future episodes and to re-listen to the old ones. Until next time, I'm your host, Michael Peregrine.
Copyright 2017, McDermott Will & Emery. All rights reserved. Any use of these materials, including reproduction, modification, distribution, or republication without the prior written consent of McDermott Will & Emery, is strictly prohibited. This may be considered attorney advertising. Prior results do not guarantee a similar outcome.